What if you have a history of addiction to drugs? Can you still get custody? Terrific question. My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues right here in the state of Michigan. And today, we're going to continue our video series. It's designed to educate and inform the public. Please subscribe to our channel. So, you have a history of addiction. Does that rule you out as a custodial parent? Absolutely not. Even someone who has a history of addiction can get custody. A lot of times, people have children when they have a history of addiction, and they have a child with someone who also has a history of addiction. That's how they met in the first place. They were both at the crack house. They both they were addicted to painkillers. They were both in the same clinic. Who knows? But the point is, the fact of a history of addiction doesn't mean you can't get custody. But it does mean you're going to have to show the court that any problem that you had has been resolved or is under appropriate medical management. The court doesn't mind people who are sick and doesn't discriminate against people who have problems. The court just wants to know that you're trying to take care of it. And if you can show that, if you can show a recovery effort, that speaks very well for you. The court will give you the same custodial opportunity that it would any other person. The court is going to focus on what's safe for the child and what's in the best interest of the child. It could very well be that even though you have a history of addiction, you have shown yourself to be a responsible adult and a solid custodial parent. So the court may very well find it's in best interest to go with that person, even if the other person has no history of addiction. Why? Because maybe that other person has other problems, other reliability issues, other organizational issues that cause that person to not be able to take the kid to school. I've had situations where one parent was a recovering alcoholic, but when the child was with them, 100% attendance. The other person just had other organizational issues, and the kid was missing, in the first half of the school year, missed 46 days of school. It doesn't matter if he's a prior addict. The fact of the matter is he's got his act together and the other person doesn't. And that's what the court's going to care about. It is essential, though, that if you have a mark in your record, like a prior drug habit or some alcoholism or something that the other side may use against you, you got to make sure that you have legal guidance on this. You don't want to walk into a situation where some lawyer gets up there and say, Your Honor, this is a reformed drug addict who can fall off the wagon at any time, who is subject to recurrence, who is subject to recidivism, and we just can't take the chance. Give him a child, he'll ruin that child, he'll go off on a binge. We can't take that chance. Well, you need a lawyer to be able to stand up and say, Your Honor, Mike, the chance that we have is that this person who's a reformed alcoholic, who's a reformed drug addict, who has shown the responsibility, the chance that that person has is to come before the court and say, I want to be a parent also. I want to have custody too. You take a chance if you deny the child the opportunity to have that example as someone who was sick but took care of the problem. That's a positive example. And the kid is entitled to have that example as well and to live with that example and to have custody with a person who represents that value. So, in other words, there's got to be some way to argue that. And you're going to need to sit down with a lawyer so that this ugly picture potentially can be put in a beautiful frame. And that's really what it's all about. Every case is different. And your case may be something that can be put and framed before the court in a way that makes it more acceptable. If you have questions about your case, reach out and we'll be glad to help you out.
248-588-30